Good morning to all of you. My name is Vinay Singh. I am an advocate by profession and currently in Bangalore. Now, today's topic is medical negligence cases in India and its remedies. So, let's start the topic. To start with medical negligence, there is no any specific enactment for medical negligence cases. There is no specific law in for medical negligence cases. Yes, we have IPC and CRPC and we have CPC and some of the established law which we are using to establish the medical negligence cases in India. Also, we try to use some of the provisions of Consumer Protection Act as they talk about deficiency in services and the consumer complaint also filed in case of there is a medical negligence. Now, coming to this, the medical negligence is still at the evolutionary stage. Still lot of development has to happen here, but as of now we are just taking help from IPC and other civil laws to establish the medical negligence. Now, what can be said medical negligence? Supreme Court has given its ruling which we discuss later, but generally what happens then when there is a wrong diagnosis of the disease, when there is a wrong medication during childbirth, there is a negligence during the surgery and negligence during the anesthesia administration. So sometimes doctors hide the truth. They say they give fake commitment ye theek ho jayega or something like that. Then it is considered medical negligence. Sometimes they fail to check the vital factor of the disease. Sometimes doctors fail to check the vital factor. Sometimes they fail to check the allergy related issues. They fail to check the patient's medical history, insufficient information regarding the risk, lack of proper skills, wrong surgery, failure to give proper attention to patients, and all this considered as a medical negligence. Now, anesthesia is also one of the part where the proper administration of anesthesia may cause the death of the patient. So it is very much important, and sometimes doctor fails to administer the anesthesia properly. Now, in IPC we have section 52, section 80, section 81, 88, section 90, 92, section 304A, 337 and 338, which we try to bring when we are dealing with the cases with related to medical negligence. Now, what is section 52? 52 talks about good faith, but it also says that there is no good faith if the act is done without due diligence, due care or attention. So doctor cannot be say that okay, they acted in good faith but something wrong happened with the patient. It is not, because if the proper due care, due diligence, proper attention is not taken, then definitely it is a medical negligence. Now, section 80 talks about accident doing lawful act, and there are other sections. Section 304A talks about the cause. They are especially talking about the death, causing death by negligence. In case a patient dies due to the negligence, then section 304A comes to the picture, and it ascertains the criminal liability of the doctor or medical staffs or the hospitals based on the fact of the case. And it can be either done by the commission of the offence or omission of the act, either commission of the act or omission of the act. Sometimes the doctor stops supply of something, it is called omission, and sometimes they don't take the proper care, that is also called omission of something which is needed and it is not done by the doctor, then it is omission of the offence. IPC talks also about the medical cases these all terms which we learned so far. These are sections we learned: 52, 80, 81, 88, 90, 92, 304A, 337, 338. All these are in general also used, not specifically made for medical negligence cases, but we try to bring the medical negligence in the same picture so that the case can be filed using the IPC, and the punishment can be ascertained properly. Now, in case the case is filed, the doctors may go for a bail, anticipatory bail, or they can even apply bail in police station based on if it is a bailable offence or not. seeing the fact of the case and seeing the sections, they can apply, they can approach to the medical practitioner, advocate, some lawyers, and they can get themselves paid. Now, coming to the Civil Liability Consumer Protection Act 1986 is the important act where all the civil cases are filed for deficiency in services. They ask for the damages and compensation. So there is a case is presented to the honorable court, and then the complaint is raised, then summons issues, then written statement is filed by other party, and after that evidence stage, expert opinion, medical journals, medical other doctors opinion, and decree passed based on that. If there is a failure from the side of doctor or hospital, if the complainant is able to establish the fact that some negligence has happened, either it is deficiency of services or in any other way, then they get compensation. Now there are some very importantly, people can approach the medical council of the state where the doctors or these hospitals are registered, and they are also entitled to deal with such medical cases. And nowadays people are getting aware about the filing cases to the medical council of the states. That is in Karnataka we have Karnataka Medical Council, and cases can be filed even in Karnataka Medical Council in case of there is any negligence from the side of hospital or from the side of any doctor. Now, medical negligence also attracts a vicarious liability in case if a person, something happens to the person, and the doctor is not able to pay certain amount, the hospital is liable to pay that amount based on the vicarious liability clause in law. Now there are some cases. Before that, I am going to talk as a disclaimer that the intention of this video is not to defame any doctor or any hospital, but the intention is to give information to the public at large about medical negligence, make them aware about their rights, and the law should be informed to everyone. So now the doctors are considered to be the second god in this land, and they get very much respect wherever they go. So some of the doctors, some of the hospitals, they don't digest this respect, and after that, just in the greed to get some money, they do some negligent thing, and sometimes it happens even intentionally. But when there is a negligence, the person has to be liable, and liable person has to pay the compensation and has to be punished. Now, Dr. Lakshman Balakrishna Joshi versus Dr. Trimbak Babu case, Supreme Court of India decided that what is negligence and what is not negligence. There is another case called Aparna Dutt versus Apollo Hospital Enterprises. In this case, vicarious liability clause was made by Madras High Court. So, in case if doctor is not able to pay, or the liability will go to the hospital itself. Now, hospitals are also held liable for not providing adequate medical facility, as it was held in Paschim Bengal Khet Mazdoor Samiti and others versus the state of Bengal. So there are different cases. Now coming to one case, which is Prabhat Kumar Mukherjee versus Ruby General Hospital. In this case, a person called Mr. Mukherjee who met with an accident by the Kolkata transport vehicle, and after that he was taken to the nearby hospital where he had presented his medical card where the limit was 65,000 rupees, and doctor said him to pay 15,000 rupees immediately to start the treatment, and believing the medical card, they started the treatment. When the person was not able to provide 15,000 rupees demanded by the hospital, the medical staffs and doctor stopped the treatment. The person was shifted to some other hospital, but on the way while shifting to the other hospital, he died. So court found him, National Commission found him guilty, in the sense that National Commission found the Ruby Hospital guilty for this act, and they fined the Ruby Hospital for 10 lakh rupees, and this 10 lakh rupees was given as a compensation to the parent of the person, Mr. Mukherjee, who died in this accident. Now, coming to the other landmark judgment, which is Kunal Saha versus AMRI. In this case is famously known as Anuradha case. In this case, 3 doctors, they failed to administer the drug allergy of a person. They prescribed some medicine which was allergic. The person was allergic, and he died. For this gross medical negligence, the AMRI was fined. The AMRI was fined for around 6.08 crore rupees, and it was given to the Anuradha's family as a compensation for deficiency in services. And there is another case, V. Krishnan Rao versus Nikhil Super Specialty Hospital in 2010. One person was treated for typhoid, but in actual he had malaria. Because of this, the person died, and the hospital was fined. The person was given the compensation of around 2 lakh rupees. Now, coming to the next case and last case. I think this is the last case actually, but see, thing is, we have to be very much aware about the medical negligence. What is negligence? What is not negligence? We gain some information whenever we have any issue. We should, as a patient, we should know our rights. We should directly approach to the civil surgeon. We should directly approach to the state health department. We can go to the state medical council for the complaint related issue, and even the punishment, doctors can go to jail, hospital can be shut down, a doctor's license can be cancelled, and lot of other remedies are also available other than the punitive and compensation and damages. So hope you are aware about the fact that the medical negligence cases in India are not so much famous nowadays. It's getting filed in some places, but still people has to be aware about their rights. So thank you so much for your time. Hope you like this video. Thank you so much again. Bye bye.